How does the Social Security Administration define disabled in Texas? Hi, I'm Mark Whitehead, a board-certified disability attorney and author of the disability help book, The Social Security Disability Puzzle, How to Fit the Pieces Together and Win Your Claim. The Social Security system uses a 5-step sequential evaluation process to determine disability. Disabled is defined as an inability to engage in work because of a documented physical or mental impairment which can be expected to cause death or which has lasted or can be expected to last at least 12 months. Under the 5-step sequential disability evaluation, the following must be proved by a claimant in order to be found disabled. The 5 steps are as follows. Step 1. The claimant is not engaged in substantial gainful activity, meaning work that earns more than $1,000 a month. And at Step 2, the claimant has a severe impairment that limits your ability to work. And Step 3, the impairment meets or equals one of the impairments described in the Social Security regulations, known as the listing of impairments. The listings are a set of predetermined medical criteria that qualify one for disability. Or, at Step 4, considering the claimant's residual functional capacity, that is, what the claimant can still do even with his or her impairments, the claimant is unable to do any past work that they've performed in the last 15 years. And finally, at Step 5, the claimant must show other work within the claimant's residual functional capacity, considering their age, education, and past work experience, does not exist in significant numbers in the national economy. Most claimants don't have a problem proving the first 2 steps, that they aren't working and they have a severe impairment. The 3rd step, meeting or equaling a medical listing, is hard to do, but fortunately it's optional. The real issue is proving what your residual functional capacity is in the critical steps 4 and 5. What is a residual functional capacity, or what we call an RFC? At steps 4 and 5 in the sequential evaluation, your RFC is the maximum remaining ability you have to do sustained work activities in an ordinary work setting on a regular and continuing basis. Now, a regular and continuing basis means work done for 8 hours a day, 5 days a week, or an equivalent schedule. Your RFC is expressed in terms of the exertional classifications of work. These classifications used by the Social Security Administration are described as either sedentary, light, medium, or heavy. Your RFC must be understood in terms of the 7 primary strength or exertional activities of work. These consist of 3 work positions and 4 worker movements of objects. For Social Security purposes, the 3 work positions are either sitting, standing, or walking. And the 3 worker movement positions are lifting, carrying, pushing, and pulling. Residual functional capacity is what the claimant can still do despite of her physical or mental impairments. In making this determination, the Social Security Administration must consider all relevant medical and non-medical evidence, including medical records, observations by examining physicians, evaluation of the medical evidence by non-examining physicians, and the testimony of the claimant and others who've observed her. In most cases, if a claimant can still perform heavy or medium work, they're not going to be disabled, so I won't go through those definitions. What usually matters is whether someone is limited to a light or a sedentary RFC, or possibly they're not even capable of sedentary activity at all. Light work activity is defined as being able to sit for at least 2 hours in an 8-hour day, stand or walk at least 6 hours out of an 8-hour day, and lifting up to 20 pounds occasionally throughout the 8-hour day. Examples would include a sales associate at a department store, a school teacher, or maybe even a lawn worker. Now, sedentary activity is defined as being able to sit 6 hours in an 8-hour day, standing or walking no more than 2 hours in the 8-hour day, and lifting no more than 10 pounds occasionally throughout that 8-hour day. Examples would include office workers, telephone sales, and other sit-down type jobs that don't require any heavy lifting. Remember, at Step 4, the claimant must show that they can't do their past work. Therefore, if a claimant's past work was as a lawn care worker, i.e. a light-duty job, and there are medical records that show they can't do any more than sedentary activity, then they've met their burden at Step 4 of the evaluation. In other words, they've proven they can't do their past work. The final step is Step 5, and it's the hardest. Here, the claimant must prove that given their age, education, and past work experience, they can't do any other work available in the national economy. In other words, they are unemployable at any RFC level. This is a tough standard to prove. However, there is some help. If you're over the age of 50, there are a set of medical vocational rules that can help. There are over 80 of these rules. Too much to go over here. But just know that if you're over 50 years of age, you have some help if you know how to use the rules. If you're under the age of 50, you have it rough. At step 5, you have to eliminate all possibility of employment at any RFC level, including the easiest, which is sedentary activity. If you have more Social Security questions, check out my free ebook, The Social Security Disability Puzzle, How to Fit the Pieces Together and Win Your Claim. Visit www.disabilitydenials.com for a free downloadable copy, or call 1-800-562-9830 to discuss your particular disability issue. I'm Mark Whitehead. Thanks for watching.